Hi everyone, it's Wayne Jones, the Course Coordinator for Australian Employment Law. This week we're looking at three very distinct topics. We're going to have a look first and foremost at control, performance management and discipline. Then we'll talk about loyalty, confidentiality and privacy, which is chapter 13 in your text. And we'll finish with a part of the discrimination victimisation chapter 14, an overview perhaps of anti-discrimination laws. But I would like to draw your attention particularly to the material at the end regarding protected action. That's, I think, the point of that chapter for us in our introductory course. But for this week, I'll start with part one, which is a discussion of what I think are the main issues in chapter 12 in the textbook. That's dealing with control, performance management and discipline. So as usual, the reading, or the main reading, is from Stewart's Guide, and I'd like you to start with chapter 12 on control, performance management and discipline. And that chapter starts with a conversation around the express and implied terms in a contract. And it makes the point that we're talking about duties here which sometimes can be spelled out in a contract if it's very well drafted, but oftentimes we're talking about terms and conditions which are implied in the contract, and there are three of them which will be implied into every employment contract almost without exception. They are obedience, cooperation and using proper skill to complete your work, and exercising care and skill when you're doing your work. Starting first of all with the comments regarding obedience. The textbook authors refer you to two cases, an older case, Crown against Darling Islands, Stevedore and Lydridge, which dealt with loading bags of lead onto a vessel, presumably in the older days when they were lumped on board, and a decision being taken unilaterally by workers as to how many was a safe amount. And of course the discussion there was about lawful and reasonable directions being given by a supervisor or a manager. So although an employee has a duty of obedience, they've got to follow lawful and reasonable directions. You can't be directed to do something which is unlawful. So look at the Darling Island case. In Kelly and Alford, the employees were arguing over workers' compensation. They needed to be in a position to make a claim against each other, including the driver, for damages they suffered in an accident. And part of their claim was based on the fact that they were required to drive an unregistered and an uninsured vehicle. So have a look at that case as well. But the point there regarding obedience is you've got to follow all lawful and reasonable directions given by the employer. So in the Darling Island case, the court was looking at whether those directions were reasonable. And in the second case, Kelly and Alford, you can't be directed to do something that's unlawful. The directions that you have to follow need to fit within the scope of the job. Now, the case which the textbook authors refer to at paragraph 12.3 is yet again another university case, Miller against the University of New South Wales. The issue there was whether a senior academic could be directed to take on other roles that he felt were inconsistent with his main role. Now, there was a fairly detailed duty statement, as there is for most jobs. I do wonder sometimes whether people look at their duty statements to at least think about what the scope of their job is. I'm sure for many people the duty statement's done and then it's perhaps never looked at or revisited for a very long time, if at all. But anyway, Miller had a look at that and said it was outside the scope of the direction in the duty statement, and he didn't need to take on these additional duties, and the court didn't agree. They said no, there was scope in that statement for him to take on the work, and that it was not, even though it hadn't been done previously. They also looked at the previous history of the role, whether that type of work had been done before. Here's a short extract from that case. It is worth a look, even if you just scan through that case. Miller and University of New South Wales. They were consistent. So what he was being asked to do was consistent with the position as an associate professor, and the proper focus was for the consideration of the duties not as previously performed. So it didn't matter if it was not something that had previously been done. If he was directed to do it, it was more about whether or not it was consistent with the role. The textbook refers to a couple of other possibilities for changing the scope, and I think you should take note of these. New technology, another location, and significant changes only if preserved in the contract. And I'll add to that, of course, significant changes only if there's been some consultation with the employee, as is now required under the National Employment Standards. All right, now remember we're talking about the capacity to direct an employee to do things. So managerial authority is another issue which is mentioned in the text at paragraph 12.4. And some of the issues the authors make, and I'll ask you to read the whole lot in detail, are these, that the authority to issue a lawful and reasonable direction to an employee is called the managerial authority. The sorts of things that have been found to be within the scope of that usual managerial authority are these: dress code, proper time recording, asking an employee to have a medical examination to determine if they're fit for work. And again, I'll just stop at that point again. You might recall we looked at when a person was about to go on to maternity leave, there was also the capacity to ask that person, as they got very close to the end of the term, to undertake an examination just to make sure they could continue to safely do the work they were being paid to do, even though they were now ready to give birth. But generally speaking, there's also it's also possible to ask an employee to undertake a medical examination, or to direct an employee to undertake a medical examination to make sure they are continuing to be fit for work. Not to make public comments about the institution or the organisation or senior management, and not to post union propaganda in the workplace. So have a look at the case examples which are given. There are some others there around harassing co-workers, etc. But the other point which is made by the textbook authors is with respect to cooperation and proper control. So that's at 12.5. Again, an interesting point, because no real definition for it. The way to determine the possibilities is to have a look at the cases again. So it's a more general requirement to cooperate with management and behave appropriately at work. So I'll just go back, look at the previous one. There was the managerial authority that said, well, there's certain things that the manager can just direct a person to do because it's part of the usual managerial authority. This is a broader duty to cooperate and generally behave appropriately when you're in the workplace. Now, I don't know all the arguments for this, but I have often made the argument myself that what's appropriate behaviour may, to some extent, depend on the nature of the workplace. Now, that doesn't, for example, excuse behaviour which would be, for example, sexually inappropriate behaviour, discrimination, sexual harassment, putting up photographs of naked people in the washroom, for example, just because that's sort of the culture. But I do think that there's a little bit of scope for a court to have a closer look at the nature of the workplace to determine what's appropriate. Anyway, have a look at some of the cases for yourself and see whether I'm correct. I'm happy to hear the other argument. Examples: insolent or offensive or abusive behaviour, not only towards the boss but also towards your work colleagues. So not unusual. We would know it here as a breach of the code of conduct, which says that we treat all people with respect. Again, disparaging the employer's business, telling people it's about to go broke, for example. And then the easy one, which is assault. Other examples: making private use of employer's property, falsifying timesheets, bribes and commissions, etc. So failing to answer truthfully was an interesting case example which was given in the text. Interesting because the behaviour was really about the behaviour of another. The issue here was whether or not the employee had answered questions about that behaviour truthfully. And away from work is becoming an area of interest these days, particularly around sporting identities. But also, just before I get onto that, just generally speaking, anything where there's a connection back to the workplace seems to be able to attract the negative attention of the employer, provided there is that nexus, that connection back to work. So usually it's two employees together, might be an employee who is identifying him or herself as a member of an organisation or an institution, etc. As long as there's that connection there, it's not unreasonable for an employer to say, this has impacted on my business. Sports is easy, of course. Sports where there's an endorsement contract and there's potential damage to reputation. The agency has purchased a particular look or image. If it's damaged and they're not interested in the new image, they will terminate a contract. Maybe in breach if it's sufficient connection with the employment, which I've mentioned, calls into question the capability of performing their duty or efficient management of a business or reputational issues. Now, just thinking about the issue here to look at, some of the issues to draw to your attention I think you need to look at. The person who was caught drink driving when the employee worked for a company which was publicly committed to the promotion of responsible drinking, that's going to call into question the capability of performing their duty. Similar examples are given at 12.6 in the text. Have a look at them because there's some interesting cases there. They do generally come back to that issue around management of the business or the proper reputation of the business. But have a look at the cases also on social networking sites like Facebook, because again that's very much an emerging issue and one which I think you need to take special note of. Employees are required to exercise skill and care, a case you've seen a couple of times now, Printing Industry Union and Jackson and O'Sullivan. The standard of care and competence reasonably expected from someone with their experience and training is what's required. So if you're outside of the area for which you're trained, you might be filling in a position, for example, might be a salesperson that's being temporarily asked to assist with books and accounting, the standard that can be expected is someone with your experience and training. There is always, of course, a general duty to take reasonable care. Interesting case example given Bolton, Gems and Grigori, where the person left a sample case full of gems in a motor vehicle and they were stolen. There was a claim, I think by the insurer, not by the employer, but there was a claim in any event on the basis that the employee had just not taken what was even reasonable care considering the value of the goods. So a general duty to take reasonable care not to cause injury or damage in the course of employment. A vexed issue is the issue around indemnity. Generally when you're working for someone, I would take it back a step. The textbook talks about the staff generally being indemnified for a variety of reasons. I think it comes back to the fact that you're acting as an agent. So to some extent, if you're acting as the agent of your employer, you are in the same position as the employer. You are their representative and their agent. But in any event, that's my take on it. I think the textbook at 12.8 refers to staff being indemnified for expenses reasonably incurred. That's probably a no-brainer. If you run up costs associated with your job, you should be able to be reimbursed. You should expect to be entitled to an indemnity, though, against liabilities that are incurred, provided it's not unlawful, and provided you're going about the ordinary course of your business. And the case example that's given there is a good one, and that's the case where the person was preparing a report, I think it was, that they were acting definitely on behalf of their employer, and then they were sued for defamation. Now, in that case, the person was found to be entitled to an indemnity. But if it's serious or willful misconduct, it's not usually going to be the subject of indemnity, even by insurance. And you may find, in fact, that that is the case, that officers and the directors and officers insurance will indemnify people in the workplace for decisions that are taken, provided they were done honestly and reasonably. But as soon as you get into the area of serious or willful misconduct, the insurer is not going to allow the claim. What about the boss? What about the employer's duty? Well, their duties are listed in the textbook at 12.9 and 12.10, and there's a discussion about a number of interesting cases there. They usually are around workplace health and safety, to maintain a safe work environment, and then around acting fairly and reasonably, although look at the commentary at 12.10 in the text, which seems to suggest that the jury's still out. Now, I'm not sure. If you have a look at the Commonwealth Bank and Barker case, this idea of mutual trust and confidence at the moment seems to be in abeyance. So there doesn't seem to be an obligation on the boss, on the employer, to act with mutual trust and confidence in Australia. I think that Stewart, in his textbook, is saying, well, look, commercial contracts are going down this path, and I'm thinking particularly around things like franchise agreements. There's starting to be implied into franchise agreements an implied term that each of the parties will act with mutual trust and confidence because it's in their interest. Sometimes it's called, or it's in the family of acting with good faith. In any event, have a look. I think that's quite an interesting comment that's made by Stewart at 12.10. Now, just on to performance management. This is, again, a fairly vexed area in the workplace. There's always a question, and you'll be asked a question, I'm sure, at some stage about whether you're required to provide written warnings. And, of course, the answer is no, although it's in the employer's interest to be able to prove that a reasonable opportunity to improve their performance was given before they were dismissed. So an opportunity to improve that before the dismissal happens. The idea of the written warning is that it's easy to prove from an evidentiary point of view. When you're performance managing, you'll see that it's from the cases, it's quite important that policies and procedures should be followed. And I would say, although there is authority to suggest that close enough is good enough, but I think that really the closer that the employer can follow the policies and procedures, the better. And always certainly around performance management, many of the procedures which are outlined prior to termination require some element of natural justice. So not all, we need to make that point, but where they are mentioned, where there is an element of natural justice, that usually means the employee should be given an opportunity to know the nature of the complaint. So what's it said that you're doing badly that you need to improve, and an opportunity to address that issue. With respect to drug testing in the workplace, there is no implied right to do it because, of course, cross the line, get it wrong, and you've committed a criminal assault. So it's safest to include it in an agreement with staff and the union or in contract terms, and, of course, the results from drug testing must remain confidential. Your text refers to issues around discipline. Note the types of disciplinary sanctions which can apply. Can I add another issue for you here, which I don't think gets a mention in the text that is worth mentioning? Some employment contracts, some enterprise agreements have a very specific process to follow for misconduct. And a mistake which is often made by employers is to issue even a warning letter without necessarily following the process and procedure that's in the agreement. can I say that even issuing a warning letter is seen to be a disciplinary matter, and so it's not open for an employer to do that unless they've followed the process. But the sorts of disciplinary sanctions which are allowed are I suppose just the straight out dismissal, demotion or reassignment. A person might be suspended for a period of time. Fines and penalties are a little bit vexed because only the state can issue a fine or a penalty. It must bear some resemblance to being paid compensation. So what you can do is you can agree an amount of compensation in advance, but if it has the look or feel of a penalty or a fine, you could be in trouble. Okay, well, they're my comments with respect to Chapter 12, and we'll talk again soon regarding Chapter 13, which is loyalty, confidentiality and privacy. And the big issue, of course, there regarding this duty of fidelity to the boss is to make sure that even after the employment relationship ends, the things that you've learned, the confidential information, etc., are not used for your benefit or for the benefit of another. They remain the property of the employer. So we'll talk about that some more shortly.